Good morning and good afternoon. My name is Kathleen Regan, and I'd like to welcome you all to a LexisNexis complimentary CLE-eligible webinar titled Non-Compete and Non-Solicitation Agreements, Protecting Confidential and Proprietary Information. Complete biographies are included with today's PowerPoint. Sterling Miller served as General Counsel, Corporate Secretary, and Chief Compliance Officer for Sabre Corporation from June of 2008 until retiring in November of 2014. Prior to that, he was the General Counsel for Travelocity.com from 2004 until 2008. Mr. Miller managed the company's Global Legal Department, Government Affairs Group, Corporate Secretary Office, Compliance Functions, and Data Privacy Team. Eric Meyer is a partner in the Philadelphia-based law firm of Dilworth, Paxson, LLP, and is a member of the firm's Labor and Employment Practice Group and chair of the Social Media Practice Group. Mr. Meyer also publishes the Employer Handbook, which the ABA Journal recognizes as a top labor and employment law blog. Lawrence Holmes is a partner in the law firm of Dilworth Paxson and has practiced over 20 years in commercial litigation. He has almost a decade of transactional experience and has represented clients in litigation and negotiations and advice in the employment area, including trade secrets, covenants not to compete, and other employment practice issues. And now I'd like to turn the program over to the speakers. Gentlemen, the floor is yours.
Thank you, Kathleen. Good morning, good afternoon, or evening to everyone, no matter where you are on the webcast today. My name is Sterling Miller, and I'll be your moderator here for the panel over the next 90 minutes or so. Thanks to everyone for joining. We really appreciate the very large number of people who are attending today. That's very gratifying for us, so thank you for that. I am currently Senior Counsel for Gober Hilgers Law Firm, and prior to that, as you know from the introduction, I was the General Counsel for Sabre and for Travelocity. And so with respect to today's topic, I have seen things on both sides of the fence, both as outside counsel and as in-house counsel. And we're going to try as best we can to direct our remarks and our presentation to both sides of that coin. And as I said, over the next 90 minutes, we'll be discussing non-compete agreements, non-solicitation agreements, both with respect to not soliciting fellow employees and not soliciting customers, so two sides of that coin as well. We'll talk about trade secrets, what they are, the best ways to protect them, and finally we'll address social media as well. And then we'll try to wrap up with a discussion about things that you should be doing now with respect to these topics. Our presentation is going to be focused on the United States generally, so apologies to folks outside the U.S., but for us to try to take on the laws of different countries is just a little bit bigger bite than we could do in one program. And for those in the U.S., we're not going to focus on any particular state. Our discussion will be general, some general themes that are typically true, but of course, as most know, how any particular situation would turn out with respect to these items is going to depend on the facts and the law of the jurisdiction. So the PowerPoint we're going to walk through here in just a few minutes is fairly high level, and that's intentional. It's done as a guide for us and for you as we traipse along with these topics. There are additional materials in the handout area. There are 4 that will give you additional information and additional depth into the topics that we're talking about. And lastly, we'll do our best to save some time for questions. Please submit those in the Q&A box. We'll probably take those up at the end, but if there are any that seem really germane right when we're in the middle of the topic, we'll try to address those right then and there if possible. As Kathleen said, I'm joined today by Eric Meyer and Larry Holmes. Both are partners in the Philadelphia office of Dilworth Paxson, and both are experts in today's topic, so we're really fortunate. Eric in particular had mentioned that he publishes a blog called The Employer Handbook, which is at theemployerhandbook.com. I've become a follower of that recently. It's an excellent blog on these issues, and I've added it to the blogs that I regularly follow, and I would recommend it to you as well. It's a really great resource. So with that introduction, I guess I'm in control. We will go to the next slide. And we're going to start with non-compete agreements, which are probably the agreements you hear most about in this area. And we're going to talk about several things, as you can see here, around key considerations. And Eric, I'm going to kick it to you first. So why don't we discuss just generally what are non-competes and why are they needed?
Sterling, thank you. Before I get to that, I have a bit of a concern. I noticed that while you were talking, the number of viewers was going up, and just as when you kicked it over to me, I see the number of viewers is going down. So I don't know what to make of that. Thank you for the kudos, but anyway, to get to your question of, why do we need non-competes? Well, it's fairly simple. Courts disfavor them. They're viewed as a restraint on trade. And essentially, as an employer, if you want to prevent an employee or former employee from competing with you, you don't have any protection unless you have one in place. Well, I guess we'll get to a topic later on, the inevitable disclosure doctrine, which may offer some protection. But essentially, to prohibit or stop an employee from competing with you, you're going to need a non-competition agreement. And what that non-competition agreement will accomplish is several things. One, it's designed or should be designed to protect legitimate business interests, such as trade secrets. And obviously, we'll talk about trade secrets separately later on. But the non-competition agreement by itself will also, in effect, protect your trade secrets. You want to protect confidential information. You want to protect your customer relationships. Now, this can also be accomplished through a non-solicitation agreement, but the non-competition agreement will accomplish that as well. You also want to protect your goodwill. Goodwill is a big item that, when it comes to enforcement of any form of restrictive covenant, but especially non-competition agreements, goodwill is a thing that judges from time to time have difficulty wrapping their heads around. And that literally is your relationships with your customers, your relationships internally. Anything that you've built up, that intangible, that has value, that if your employee leaves, could dissipate. It's often difficult to put a value on that. And when employers ultimately move to seek legal relief to enforce a non-competition agreement, you're looking at trying to maintain that goodwill.
Eric, if I can, this is Larry Holmes. Eric, one way to define goodwill, and especially if you're in front of a judge who's having difficulty getting his or her hands around the concept, is go back to the accounting definition of goodwill, which is basically the book value of the company, the difference between the book value of a company and what somebody is willing to spend on it. That is something that ultimately gets booked when people buy new companies and exchange assets like that. And it is that amorphous, difficult to value je ne sais quoi that makes the company different from another company. And, that goodwill, what creates that special sauce, and we're going to use that expression a million times today, is goodwill. And that, going back to an accounting definition of it may help you in a circumstance where a judge is saying, I'm sorry, Mr. Meyer, that's just, what you're saying is too ethereal for me.
Yeah, you're right, Larry. It's like a big pot. When you're cooking up a cake or something, there are so many ingredients that can go in. You've touched upon a few of them. Plus, the training that you give to your employees, the time that you dedicate to bringing them up to speed, to making them valued members of your organization. That's something that you have a right to. Well, you can't force them to stay, but there's a value that you've paid for by employing these people, by maybe giving them something extra to agree to a restrictive covenant. This contributes as well to the goodwill.
Eric, you mentioned that courts disfavor them, and sometimes are concerned that you are just undertaking an anti-competitive. You're introducing anti-competitive measures. What would How do you talk a court out of that?
Well, the foundation is having a legitimate business interest to enforce a restrictive covenant. One of the hot stories that hit in the fall of last year and has carried into this year is an attempt by a sandwich-making chain. And I don't really want to say their name because I don't want to give them any unfair publicity. So let's call them Jimmy J. No, that's not good. Let's call them J. Johns. That's even better. And the report was that they were making all employees from the top of the line down to the sandwich maker sign a restrictive covenant, an agreement not to compete within a certain geographical radius for a certain period of time. And the heat that the company took was, why would you want to restrict people who are making sandwiches from earning a living? What secret sauce, no pun intended, do they have that would create a competitive risk or somehow harm your business unduly? What legitimate business interest does this company have to enforce those agreements? And that's something that you're going to have to press upon a judge immediately if you're trying to enforce one of these things is, why should I make an employee with far fewer resources than you, employer, sit on the bench for a year, 18 months, 2 years, whatever it is? You have to be able to show a legitimate business interest.
Hey, Eric. I'm sorry, Larry.
Yeah, go ahead, Sterling.
Okay, that raised that case just raised a good point, a good question, I think. Can you talk about what type of consideration you would have to give an employee to enter into the agreement? And if you think about the timing, does it matter whether you're asking the employee to sign before they become employed, or what happens, or what are the circumstances when they are already employed and you would like them to sign a restrictive covenant like this? What are the kind of the rules of the road for people in terms of trying to accomplish that?
Well, here in Pennsylvania, Sterling, they can just at the start of the job, with no extra consideration, put a restrictive covenant in front of the employee and make it a condition of their employment. There are certainly other states, and I can't speak to all of them, that require some separate consideration. There is then a question as to whether or not you can decide to create restrictive covenants in the midst of an employee's employment relation with your company, and whether that has to be separately supported by additional consideration. There could be a restrictive covenant that accompanies a promotion to a job, so a state that requires separate consideration could consider the promotion or the increase in pay. There are other states that consider every day that they don't fire you is new consideration for working there, and therefore they could put a new restrictive covenant in front of you every day. It's an extreme view, and it's really state by state. Eric?
Oh, I think, Larry, you hit the nail on the head. The only nuance I would add to that is that in certain states, and frankly I couldn't tell you which ones, but in certain states, at-will employment would not be sufficient consideration even at the front end. Hiring someone forcing someone to agree to a restrictive covenant as a condition of initial employment wouldn't be enough in those states where that employee is employed at will. That would be insufficient consideration. But by and large, Larry's right. The safest way to do it is make it a condition of initial employment. And otherwise, if you want to have someone abide or agree to a restrictive covenant midstream, then you're going to have to generally provide additional consideration unless you're in a state like, for example, New Jersey, where continued employment is recognized as sufficient consideration to support entering into a restrictive covenant with an employee mid-employment.
And for the folks on the call who tomorrow have to make the decision, what am I going to do with this employee who I'm about to promote, or this employee I'm about to take on for another company? Think about this. No matter what the law in your state is, you will have to appear if this becomes a litigated dispute. You're going to appear in front of a judge, and 9 times out of 10, that judge is a human being who is going to, regardless of the law in that state, look to the fairness of the situation that generated the creation of the contract in the first place. And if you're not sure in your state, you err on the side of additional consideration. You err on the side of a negotiation of this agreement as opposed to a boilerplate document that's put in front of them in microscopic print and with no time to evaluate. You consider giving them 24 hours to take it home and talk with their own lawyer about it. You maybe even have a part on the form that says, I have had a chance to review this with counsel and I sign it willingly, and et cetera. So even if you're in a state that is extremely pro-business, you do have to think about the fact that your case will ultimately be decided by a person in a robe who is probably going to try to do what they think is right. And in those circumstances, don't do the absolute bare minimum. And then another, a very important point that really is countrywide. These things have to be restricted within their scope, within their time, within the specific job that somebody does. A court is not going to let somebody take a job with your company and then agree by working for you that they will never agree and they will never work again in their chosen field for any competitor of yours anywhere in the nation. Those are the kinds of agreements that the courts are not going to enforce, and then you're going to get into the situation where you're in a court that may edit a document like that, and I think New Jersey is a state that blue pencils agreements. Pennsylvania is a state that does that. And there the court will tailor the agreement itself to the least restrictive means that the state or the courts have found palatable in that jurisdiction. Other jurisdictions will throw the agreement out entirely because you went too far, and they are not interested in rewriting or renegotiating the contract. They just consider the contract void from void ab initio. So it is important that you have reasonableness in your geography. It is important that you have reasonableness in the scope of the job that the specific person is performing for you. And it makes sense that what you're trying to restrict them from truly is competition and some harm that you could articulate one day to somebody who's deciding this case.
Thank you, Kathleen. Larry, that was really an interesting discussion on some of the terms that work or don't work. So one question that I have, and I think maybe the folks participating in the webcast do as well, is, all right, I'm a company that has employees in 6 states or 10 states here in the U.S. Can I do a one-size-fits-all, meaning I just kind of pick the lowest denominator? Should I try to customize the document for each state that I have employees in, or what are the pros and cons of thinking that way? And I'll throw that to either you or to Eric to answer that one.
Well, Sterling, I think Larry hit on a few of those points, and I can expound upon them. Frankly, in terms of the consideration element, because it's going to vary from state to state, maybe not so much at initial employment, but if you're signing people up mid-employment to a restrictive covenant, having a one-size-fits-all approach may not work. You could try putting a choice of law provision in the agreement that says that, for example, New Jersey law applies. I'm based in New Jersey. I know that in New Jersey I can sign people up midstream and have continued employment serve as the consideration for the restrictive covenant. But if I have operations out in California, I find it hard to believe that signing up a California employee to an agreement that has a New Jersey choice of law provision where the employee is going to continue to work out in California, I find it hard to believe that a local California court is going to enforce that. Or even if you have a form selection clause, whether a New Jersey court is going to put a California employee on the bench.
In fact, I seem to recall that California is particularly particularly problematic in that scenario, that a California court will intervene and prevent a Pennsylvania court from ordering a California person not to work for another California company because of something they signed with the mothership back in Pennsylvania. I hope I'm not creating a ridiculous misstatement of the law, but I remember dealing with that issue particularly 2 years ago when you and I worked on a matter, and it was a number of people were being taken away from the company. And Sterling, your question, the one-size-fits-all in a company that works in 6 states, I think is exactly the wrong idea, because a company that works in 6 states has so many different strata of employees, and each of those different levels should have their own agreement tailored to the work they do and what it is the company is trying to protect. The non-compete agreement that should cover your C-level officers, your CFO, your CEO, your COO, that should be based on the law of the mothership. That should be based upon the geographic area the entire company works in, because those people work they function in the entire area, and it is perfectly reasonable for them to be expected to live under Indiana law if it's an Indiana company that operates in the entire Midwest. Move down if you're in a sales-based company, into your sales forces that have more regional bases, and in those circumstances you should be using agreements that are based upon the region that person's in. And the person whose region is Ohio and Indiana and Pennsylvania, or Ohio, Indiana, and what's below that, Kentucky. Any one of those 3 states is something that somebody operating in those 3 areas could be expected to have to live under, and none of those courts would be offended by one of their citizens being held subject to a law in a state that borders them, as opposed to trying to impose Maine law on somebody in Nebraska who wants to go work for another company next door. And if you've tailored your agreements along those strata, you've already built in a structure that helps you explain to the court when the court says, why do you need this agreement? You say, well, because this matches perfectly what we do with our company. And you don't have the effort of trying, after you've done a one-size-fits-all and realize that one size fits none, trying to shoehorn each of the different types of people and types of workers who have just one big generic agreement and trying to explain why that works in those particular circumstances. Now, I'm describing for all the general counsel on the call, yet another reason why they're supposed to hire lawyers who are going to prepare all these different agreements for them and spend this money. But it only takes one, disastrous piece of litigation to have your agreements thrown out, especially at a high level, and realize the money that you didn't save by not spending it earlier on a more systematic, tailored way of creating these agreements.
I will say that in terms of a possible one-size-fits-all agreement, although it's not going to work throughout the country, there are certain terms for which there should be continuity throughout the country. How you define competition should be similar throughout. And that should be a pretty narrowly tailored definition. In fact, when I draft my agreements, I list out, or at least I give the client the opportunity to list out some of their specific customers who are absolutely verboten for a former employee to become employed by. But the definition of competition, the definition of who is a competitor, should be consistent in whatever agreement or agreements you use in your 6 states. Similarly, the geographic scope and the temporal scope should be similar, if not the same. I mean, generally, in my experience, 2 years or less is a pretty reasonable temporal scope, and you're going to want to be consistent throughout the country. In the geographic scope, generally the way I've seen it morph into, it used to be, within a 50-mile radius of such and such. Now it's pretty reasonable to say you can't compete where we engage in business, where we have physical operations, or where we do such and such amount of business. So to the extent that you're going to have an agreement or a set of agreements that are utilized throughout multiple states, those are some of the terms that should mirror each other within those agreements.
And how about, it feels almost like there's a sliding scale a little bit in terms of the the folks at the top of the food chain might have a longer duration and maybe a more restrictive, more restrictive covenants, whereas lower in the food chain, so to speak, it may be shorter, it may be a little less restrictive, it may not be quite as burdensome, and it seems like that's something courts would go along with. One of the things that I've seen in some recent non-compete agreements, and I don't know, Larry, Eric, if you've seen this as well, but I had never thought about these before, which may be bad on my part, but one is a tolling provision. So that would be if the employee, let's say it's an 18-month term, and the employee violates it after 6 months, that 18-month term would basically be frozen and would pick up again to be taken out to whatever the fulfillment of that term would be after it was resolved whether or not the employee, I guess if the employee was in breach. And then secondly, a clause that talks about banning preparation to compete during employment. So if someone is there thinking about leaving and taking files and doing things like that, it would actually be a breach of the non-compete agreement. Is that something you either of you have seen or are familiar with, and how do those play in courts?
I've seen the first one you referenced, Sterling, that if the court deems that, or a court of law deems that there is been a breach of a non-competition agreement, that the temporal scope, the restrictive covenant period, be it 1 year, 1.5 years, whatever, will restart and pick up from the date of essentially the injunctive relief or whatever relief that the court affords. That way you get the full benefit of the bargain that you struck with your employee, that he or she is sufficiently deterred and punished for violating the agreement that the two sides struck.
But to counter that, the court you have to think back not just to labor and employment issues, but you have to think back to general litigation principles and ask yourself whether or not a court's going to consider a provision like that to be an unenforceable penalty. What you're trying to do is negotiate 9 months, where the other person can't do anything. Well, 5 months into it, you're in litigation with the person. You are kind of thwarting their efforts to hurt your company, and adding, adding time to your sentence and asking the court to do that. I think you run the risk of that provision being deemed a penalty because it doesn't really relate to the harm you're trying to correct, and that the imposition of that extra term does indeed correct that harm. It's like saying if you don't pay me $100 by tomorrow, you owe me $10,000 next week. I mean, if you can truly explain that it's difficult to assess the damages and that this is a reasonable estimation thereof, maybe you get past the penalty argument. But I think stretching out the time is a penalty issue. When you asked about the CEOs versus the regular workers, think about what's at stake for the company as they expose itself to the specific worker. So the woman sewing the shoulder pads into the latest Italian design from some very exclusive dressmaker, in Milan, does not have the same information about the entire pattern as the master designer for that year's lines would have for that designer. A CEO has an existential view of the company, and a CFO has almost an X-ray, almost an orthopedic view of the company that exposes that company to its competitors in a very dangerous way if that person can freely go to the next place and disclose everything they know. And that is covered a lot by trade secrets, but it does explain why you have different varying levels of this, because you are, at the end of the day, trying to match the remedy with the potential harm. And, one of the persons in your local sales staff working out of Dublin, Ohio, does not have, on their best day, cannot have the kind of seismic effect on the future of the company as your senior vice president in charge of all of office equipment in a large finance company.
Right, right. Yeah, I think those are excellent points, that tailoring the agreements depending on the job or the person's responsibilities will serve you well down the road.
Yeah. To me, the document that wins in court, and almost always wins, is the document that was drafted for that person. The closer you can get to a document drafted toward that person and the duties they were going to do in the company, the better the better the court is going to look at that document, and the more effective it's going to be. And if it's not to the person, then it's to the person's job. And then when that person changes jobs and you have a review, and we're about to, I think we were going to get into this about what are good practices. In the review set, if somebody's elevated from a credit analyst 1 to a credit analyst 2, have a new form of non-compete. It doesn't extend the time, but it changes the scope, and it describes the difference of their new job. And if you have those in place for varying levels of officer levels, vice president, senior vice president, executive vice president, then you don't have to rewrite them every time for the person, but you're always taking a very individualized step to match that document to that person you're trying to restrict from doing something. Because look, at the end of the day, these things are only worth anything if you can cause a court to order that person to sit for 6 months or 9 months or 12 months and not work and not do what they do while the other company's paying them, or maybe while the other company isn't paying them, and enforce your agreement. And that's the only value you get out of these. You want to write these in a way that a court would not be reluctant to, let's face it, wield the ultimate hammer in civil law, which is to enjoin somebody from doing something. Enjoin somebody from doing the thing they do for a living.
Yeah. You mentioned, the new company may be paying that person while they sit. So let's advance to slide 1.
Yeah, let's jump to 6.
And let's take a look at, so your company, you're the new company, and you're going to hire someone, and it turns out they have a non-compete. What are some of the things you should be looking at right off the bat if that's a situation that's coming your way?
You just set up a great part of the question just by saying it turns out they have a non-compete. If you find out the day that guy arrives at your office, if you're the president of the company and you find out your new vice president has a non-compete, and you find it out because he tells you on the first day, you should have a long talk with your HR people and whoever else had this conversation, because this should be something that people should know in their initial conversations with these folks. Because if your company wants this person, then it means the other company probably likes having her as well, and have taken steps to try to keep her in the company and keep her happy and protect themselves if she were to leave. So you've got to know. You can't say, I didn't know anything about a non-compete. I didn't know. That is not 2015 practice to act surprised when somebody, especially at an executive level, comes on board to your company and you didn't know that they may or may not have been subject to a contractual agreement not to compete. And this should be, by the time that person's arrived, your own lawyer should have looked at their non-compete. You should already have made provisions for and budgeted what it will cost to litigate this fight, what it will cost to sit this person for 6 months. You should be thinking about what is your reasonable approach as soon as they call you and say, we're going to sue you. Say, how about we agree to 3 months of gardening? How about we agree to 6 months of gardening? We'll pay for 4 of them. You pay for 2 of them. It's amazing what people will do who want to keep their employee from working for somebody else. It's amazing what they will contribute to if they know that you recognize they have rights and that what they're trying to do isn't just, trying to deprive this guy of a living, trying to starve this guy's children, trying to keep this woman from advancing in her career, whatever, all the things that new co say and yell at old co, and old co's trying to enforce their rights, is of course what new co will be saying 3 years from now when one of their people tries to go somewhere else. But the point is, have done that, have had that analysis where you have seen the non-compete. You've asked the employee, what did you have access to at your company? I don't mean tell me the combinations of the safe, but tell me the categories of information that these people are going to be squawking about. Very carefully determine the circumstances of the departure. Is this person being forced out? Was this person begged to stay and offered a lot of money? Make the evaluation as to whether what you're hiring this person for is what this person used to do at the last company. In which case, if this person is taking on different tasks and will never, you will never have the overlapping Venn diagrams of their clients and your clients, or their old job and your new job, then you may be able to talk these people out of litigation and you could put in writing, this person will not be doing A, will not be doing B, will not be doing C. And you're going to assess the risk and the reward of bringing on this person and knowing they're coming from a place willing to have a fight. That is the and they should arrive on the first day and sign something on your letterhead that says, I acknowledge that I am bound by the terms of this agreement I had with Old Co. and have discussed with you, and assert that I will not violate those agreements. All things that make the new company look good and protect the new company from being alleged to be complicit in poaching people or in trade secrets. And, trade secrets and non-compete, two different things. There's nothing wrong with NewCo taking somebody from another company who's subject to a non-compete. That is between the old company and the employee. But the fact is the employee may be enjoined from working for your company, so it has a direct impact on your company if you want that person to work for you and they can't. It's a whole different story if you take somebody from an old company, whether or not they're subject to a non-compete, and you take that person knowing that their brain is chock full of trade secrets, and that you are hiring that person specifically for the specialized knowledge they have that other company has guarded assiduously, has made profit from, and has kept from the public domain. In that circumstance, new company is doing something wrong and something actionable, as opposed to just being the potential blowback zone when the other person gets enjoined from working for you for a while. Here you could be actually guilty of misappropriating trade secrets by targeting this person that you know has that information, and you get them and you do it on purpose, and you do it to mine it.
Does it make any difference when you're analyzing, someone coming over with a non-compete, the reasons why maybe they were terminated, if they were, just laid off, or if they were fired for cause, or does it make any difference in the analysis in terms of why the reasons why they left the prior employer are now on your doorstep?
Well, Eric's seen so many astonishing ways to fire people. I'm going to give this one time.
Okay.
Yeah, I guess we employment lawyers, it's hard to make us blush, and I guess that holds true here in the restrictive covenant context. But Sterling, to answer your question, yeah, and it definitely varies from state to state. For example, here in the Commonwealth of Pennsylvania, where Larry and I are sitting and participating in this webinar, if you fire an employee because the employee, she's just no good at her job, you're essentially saying that this person is not a competitive threat. So if you're then going to try and go out and enforce that restrictive covenant you entered into with this former employee, you're going to have a tough time convincing a judge that the judge should put this employee on the bench for 12 months because the judge is going to ask, or the other side's going to say, why'd you get rid of her? Well, she wasn't good at her job. What's the competitive threat? And no judge is going to enforce that. In fact, there's case law that supports allowing that employee to work for a competitor. Now, as we eventually get into non-solicitation, that's a different story. But just sheer competition, a person who is fired for cause, so to speak, due to poor performance, you're not going to be able to enforce a non-compete here in the Commonwealth of Pennsylvania. Now, if we vary that scenario up just a little bit, and you terminate an employee because he or she has, and I've experienced this before, not myself, but I litigated the case, the employee has a drug problem. the employee is a very good salesperson but happens to have a drug problem, has been incarcerated a few times. Because this person is such a good salesperson, you've stuck it out with them, but at some point, enough is enough and you have to let the person go. That's a situation in which you probably are going to be able to enforce a restrictive covenant because the employee is good at his or her job. It just so happens that there's another for-cause reason that you terminated his or her employment. Now, if you go to a different state like New York, now I don't practice law in New York, but I've done a little bit of research on these issues up in New York, it's a 180 switch. So if you terminate someone for cause, that employee hasn't lived up to his or her end of the bargain. That is, she was employed. She essentially represented that he or she is going to be good at their job. They didn't come through. They were poor performers. The court is going to allow the employer to enforce that restrictive covenant. Conversely, if the employer is laying off the employee through no fault of the employees, then the New York courts view it as unfair to enforce a restrictive covenant against that employee. So a long-winded answer of really it depends on what state you're in.
And well, that reminds me, and I think
go ahead,
these aren't any fun. These aren't any fun if I don't give if we don't give examples from court. The exact opposite situation happened in a case we were in where I have put on the testimony of a very senior person explaining how the loss of this very important salesperson and the knowledge he had about our pricing and about everything that we were, all the relationships we built up with a number of customers, that we were really at risk. And on cross-examination, the bad guys put up some of our internal email because as soon as the person left, there was obviously a big scrambling. And in producing emails back and forth between the people, one of this guy's direct reports writes to him and says, the sleeping giant has awoken. This guy will not take a single client. He won't cost us a single cent. And it was just a younger guy bragging about how he was going to take over for this guy and nothing was going to happen to the company. And in this situation, Newco was basically saying to the judge, look, here's Old Co's people, internal people saying that this really has no effect. Now, I'm not suggesting anybody tell their employees not to have that kind of attitude, and obviously I explained to the court, I'm like, look, if I don't have employees who feel this way, that they're going to step in the shoes of somebody who leaves, then then I need new employees. But that's the kind of thing the court's going to look at. Not only what is your potential impact, but what is the impact of the person leaving? Because it's rare. It took us, in one circumstance, we had a person leave on Monday, and we were in federal court on Wednesday trying to get a TRO. 7 weeks later is when the court was finally having the hearing on the preliminary injunction. Well, that person's worked for 7 weeks after that, and the good news was you have impact if there has been impact of the person leaving. The bad news is if there's been no impact, it's a legitimate question to say, well, what has happened in the 7 weeks that this person has left? So, not sure if I went too far afield there, but.
No, actually, Larry, I think that's a great entree to the next slide, which you're the company now, and you have someone with a non-compete agreement who is leaving, and it may or may not be contentious. Let's just kind of step through for the folks listening in. What should you be doing when you're looking to enforce non-compete?
Well, the first thing you want to do, depending on what the relationship, let's assume the departure isn't violent, and I use that word with a small v, just that it's not bitter, it's not angry, the person is going to another opportunity, and that in that interview you're going to have some honest discussion. In that discussion you're going to find out why is the person leaving and where are they going. Immediately start thinking when you find out why they're going and where they're going, what it is they're trying to do. You're going to be able to figure out pretty quickly what kind of information is this guy going to use against us, what kind of, how vulnerable are we to those certain clients that develop relationships with these people. When somebody says, I'm going to this new company to try something completely new, I'm spent my life in engineering and now I've got a chance in sales. That's one thing. Versus somebody says to you, I've been just kind of drifting around here, region to region. I finally got a chance to run all of Northeast. Well, you're going to have direct competition for all your clients in the Northeast from a guy who's gone from region to region, probably mining the best people that he can get. So right there in the exit interview, you've got a chance to get basically free discovery of what's happening. That's the place to put that agreement back in front of the person and say, remember, you are subject to this. And remember, we are authorized under this document to park you at home, to garden, as the English say, for 9 months, 15 months, 18 months. If you're going to be going to a job that entails these types of situations, you're going to reaffirm in whatever letter, whatever kind of final communication you have between your former employee and you, and you're going to, your counsel is probably going to reach out to their counsel, or you have a relationship with with NewCo. Somebody there is going to call and say, this guy is subject to a non-compete, and we are aware of it and we're watching it. That can be, if the new company doesn't know this guy has a non-compete clause, that can be a pretty bad call for that company to take. But again, that's more shame on the new company than shame on you for disclosing it. And then you're going to, at that point, the person has left, and you are thinking about what to do pre-litigation. You are evaluating, what is this going to cost me versus what am I going to get? What is my, what am I really trying to enforce here? Am I just really hurt that Eric Meyer is leaving my firm after all this time and after all I invested in him, and that really at the end of the day somebody is trying to assuage honest to goodness hurt feelings, and these are real things, as opposed to this person has control of 35% of this market here, complete and total control, and will have seismic financial effects on my company. That's the evaluation you have to make, and at that point, you then decide. Then you're going to have a new set of eyes look at that non-compete covenant and talk to you about its enforceability. Find out what its holes are, and not only assess the enforceability of the contract just on a purely legal standpoint of how it's written, but reassess the enforceability based upon your review of the person for the last 5 years. How's that gone? The track record of that person in the company, and as to whether or not you're going to have support for the argument you make. You have, there's a lot of ethical considerations that go into the employee leaving and the employee coming back. Both for new co and for old co. There's a number of rules of professional conduct. I would suggest 4.2, communication with persons represented by counsel, 1.4 on communications generally, 1.2 on candor to the tribunal. Very important one, 1.8, conflict of interest in current clients, which has to do with the conflict of the company versus the new employee and where those interests may diverge.
Well, Larry, as I listen in, I'm kind of now thinking of the opposite side of the coin, which is, what if I don't have an agreement in place and it's someone who's really important to the company and they're going to a competitor? Eric, you mentioned inevitable disclosure at the very beginning. Is that something I could rely on? Is that going to be widely accepted, or is that pretty narrow depending on the state? What do you do in that situation? You're kind of up a creek.
It's narrow. The leading case, at least around here in the Third Circuit, is Bimbo Bakeries versus Botticella. Bimbo Bakeries, for those who aren't familiar, they're a sponsor of the local Philadelphia Union soccer team. They bake bread. They bake Thomas's English muffins. There are only maybe a handful of people at Bimbo Bakeries that know how to get those little nooks and crannies into the Thomas's English muffins, and Mr. Botticella was one of them. And the facts of this case are such that Mr. Botticella, he didn't have a non-competition agreement signed with his employer, Bimbo Bakeries. He didn't have a non-solicitation agreement with Bimbo Bakeries. But what he did have was a lot of secret sauce up in his head. He knew the secret to the nooks and crannies, and the way the fact pattern broke out in a lot of these cases, they're very fact reliant, they're very circumstances reliant, and this is one that just didn't bode well for the employee. He smelled bad coming out of this. He had accepted a position with Hostess about a month before he informed Bimbo Bakeries that he was leaving to go to Hostess. And during that approximately 1 month or so intervening period, he was attending high-level meetings at which he claimed at deposition that he was able to kind of tune out his brain and not take in information, and the court didn't really buy that. In fact, I think the court dropped a snarky footnote on that argument. But he is all the while exposed to information from Bimbo Bakeries, in addition to the information that he already had through his time working there. So even though he didn't have a non-compete agreement or a non-solicitation agreement, Bimbo Bakeries sought an injunction to stop him from going to work for Hostess once it found out that Mr. Botticella was going to work for Hostess, arguing that it was inevitable, because the two were such close competitors, that he was going to disclose trade secret information or confidential information that would be so much to Hostess's benefit and so irreparably harm Bimbo Bakeries that the court should enjoin Mr. Botticella from working for Hostess. And that's exactly what the court did. The lower court enjoined him. The Third Circuit affirmed. And that's where the basis was the inevitable disclosure doctrine, that this gentleman had so much top secret information that he just couldn't wipe out of his head, that it was inevitable that in going over to a competitor that he was going to utilize and share this information. So in that particular situation, the court enjoined Mr. Botticella, but that's not something as Oldco that I'd want to have to rely upon. You're much better off with a narrowly tailored, carefully drafted non-competition or non-solicitation agreement, if that's what you want. If you want to stop someone from competing, have them sign an agreement.
And we talked about this earlier, that the trade secrets and non-compete are kind of two different areas that overlap, in which where old co can get relief if they think that employee who's going to new co can hurt them. And trade secrets are they vary state by state, but 47 of the 50 states have adopted the Uniform Trade Secret Act, and it's never okay to give trade secrets to the new company, and it's never okay for the new company to encourage others to disclose the trade secrets. And I think in the Bimbo case it was pretty obvious, and correct me, Eric, if the court directly contradicted this, but there was no question that Hostess wanted this guy for his knowledge, including his knowledge of the nooks and crannies in the Thomas English muffins. And there wasn't a lot of other. He's a wonderful baker, and I'm sure a smart guy, but it was the knowledge in his head gained at Bimbo, and gained in the context of a very closely held, kept trade secret. So, and it's worth describing right now, just real fast, the definitions of trade secrets, just so. Pennsylvania has a slight variation of the Uniform Act. Basically, if you'll excuse me, I'll just go ahead and. Trade secret as defined in the Uniform Act is information, including a formula, pattern, compilation, program, device, method, technique, or process that derives independent economic value, actual or potential, from not being generally known to and not being readily ascertainable by proper means by other persons who could obtain economic value from its disclosure or use, and 2, is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. We've said secret sauce a number of times. The most obvious trade secret in the world is the combination of the 27 herbs and spices that make up the Colonel's famous recipe for Kentucky Fried Chicken. That is nobody. Churches, McDonald's, Burger King, none of these folks are allowed to hire somebody from KFC and get that trade secret. The trade secret is kept carefully. Means are used to keep it from those things from being disclosed. And that is an area where old co still has the ability to get relief if new co takes somebody from them. Eric.
In doing research for this webinar, did you know, I found this, did you know that at Coca-Cola, there are only 2 people who know the Coke formula at any one time, and they're not allowed to fly on the same flight?
I have heard that, there's an interesting thing in the Uniform Act itself. It has a number of comments, and one of the things they talk about in the comments is what is a legal way to get trade secrets, proper means to acquire a trade secret versus improper means. It is proper to discover it by your own independent invention. If I put those sauces together and somehow match KFC, I've done it. If I can reverse engineer a project, that is okay, a product. If I can discover it under a license. If I can observe the item in public use or on public display and then glean from it the secrets that make it up. Or if I obtain the trade secret from published literature. An example in the comments that is not lawful conduct includes flying a plane over a warehouse to determine a competitor's plant layout while it is being constructed. Another thing about being generally known, a fact does not have to be generally known by the public if it's generally known among the people who would know this type of thing. So a certain method of casting metal may be completely foreign to me, but all knowledgeable people in the foundry industry know this particular thing, so it wouldn't be a trade secret. But the key to protecting trade secrets, the key to maintaining that you have a trade secret is to show that you take reasonable efforts to protect those secrets. In the financial world, that includes, as you get higher in an organization, you get access to greater amounts of customer lists or different types of products that your company offers, and that, or your access into the computer system is based upon a certain level that you've achieved within the company in terms of title. Also means of protecting stuff electronically, requiring not just a sign-in but a security fob, and other means to make sure that unauthorized people don't get access to something electronically. Those are all indicia of your reasonable efforts to keep your trade secrets safe. And in those circumstances, you're not going to get the court to say, generally, you're not going to get the court to say that this person is enjoined from working for you, but you can get damages and injunctive relief that the person can't work for you and disclose that information, and to the extent that you can quantify the damage that has come to you from the disclosure of that information, you are entitled to it and attorney's fees under the Trade Secret Act.
Yeah, keep in mind that judges are going to look at certain claims of trade secret protection with a jaded eye. Larry and I, we handled a case once where we had someone on the stand and the judge interjected and said, whoa, what's so proprietary about this pricing information? If I sell used cars for $100 and I want to undercut that used car salesman by charging $99, can I just do that? What's so proprietary about the pricing? So you want to make sure that whatever it is you're placing the label of trade secret or confidential information on truly is trade secret, protected, or in fact confidential. You're not limited to the Uniform Trade Secrets Act. Obviously, you can enter into agreements with employees that define a subset of confidential information. But at the same time, if you're listing everything under the sun as confidential information, you're going to have problems. Not only does it dilute the trade secret or confidential value of information that truly is confidential, but you may be running afoul of laws like the National Labor Relations Act. Recently, the board has taken a close look at confidentiality provisions that one might find in an employee handbook, for example. And when companies label things like employee salary and benefits and other terms and conditions of employment as quote-unquote confidential, the board's going to step in and say these are unlawful provisions and possibly strike a confidentiality provision altogether. So you want to be really careful about what you're labeling as confidential and make sure that it truly is confidential, making sure, as Larry discussed, that you're taking steps to ensure the confidentiality of this information, be it through electronic means, other security means, or something just as simple as stamping confidential on a document. That helps. It might not be the be-all and end-all, but that helps.
Let's move forward just a little bit. I think we do have a slide on trade secrets, but that was a pretty good coverage, and I also think it was important in light of
you're trying to
enforce.
Sorry to cut you off, Sterling. I want to add one thing with regard to the trade secrets. Sometimes, as I said, the Uniform Trade Secret Act defines trade secrets in one way, but sometimes the state, the particular state you're in, is going to help you in the circumstance. Pennsylvania, for instance, includes explicitly a compilation including a customer list. Now, a state that doesn't include customer lists in its trade secret, you're going to have a hard time explaining that who your customers are is a trade secret. A state that adds that to their uniform law is making that is doing your work for you, and you want to know your individual law with regard to that. Illinois is similar. California is not. Sorry.
Great. Well, that's a perfect transition to the next slide or next series of slides where we're talking about non-solicitation. So these are agreements, where the party is agreeing not to solicit his or her fellow employees or not to try to solicit your customers. Let's just talk generally, how do those agreements work, and are they generally enforceable, and what are some of the key things for folks to keep in mind as they try to draft these or put these into place?
These agreements work well, provided that they're carefully and narrowly tailored. The geographic scope, whereas a non-compete agreement has to be reasonable both in geography and time, the geographic scope isn't really germane here because you're talking about specific customers that may be located anywhere throughout the country or the world. These are your customers as Oldco, and the benefit of the bargain that you're getting with your employee when you bring him or her on is that when that person leaves, or even during the course of their employment, they're not going to try to take those customers from you for a reasonable period of time. And in my experience, 2 years or less is generally a reasonable period of time. Anything beyond that is going to be pushing the envelope a bit. But in terms of terms that work, having a written agreement is a great starter. As with a non-competition agreement, in theory, you could do one orally, I suppose. Although if you go over a year, there may be a statute of frauds issue, but it's certainly better to have a meeting of the minds on paper, so to speak, or at least to reduce that meeting of the minds to paper. For a non-solicit, you want to have a clear definition of who the customer is. Again, list out some examples. Have a schedule attached to your non-solicitation agreement, setting forth a list of customers, including without limitation these customers. Define in the non-solicitation agreement what it is, what services you provide and to whom you provide them. So we have a sense of the type of people who would be utilizing your services. Customers don't just have to be current customers, but they can be prospective customers as well. Obviously, someone on a big laundry list of prospective customers who you haven't contacted for 5 years, there's much less legitimate business interest in protecting communications and attempts to solicit those quote-unquote prospective customers, but ones who you've had deeper conversations with, a court is more likely to protect. You want to carefully define solicitation. Are we talking literally the word solicit, or are we talking about solicit, communicate with, attempt to get business with, actually get business from? And I think you want to be as broad as possible. If you don't want your former employees even talking to your current customers, say so. Don't rely upon the court to assume that. Because again, these are viewed as restraints on trade. And a court is going to, you'd think, go into this situation favoring the employee. The types of solicitation. There's the direct solicitation. I, as the former employee, call up a customer of Oldco and say, do you want to come with me to Newco? And then there's the indirect solicitation, where I go from Oldco to Newco, and rather than calling up my customer from Oldco, I have a colleague call up my customer from Oldco and try and bring them over to Newco. That's a classic indirect solicitation. And yes, in theory, just putting the word solicit in there should encompass direct and indirect, but I think most people, as a matter of draftsmanship, will put those words, direct and indirect, to modify what constitutes a solicitation that just will violate the agreement. And lastly, it should cover both post-employment and current employment. So, if I'm ramping up to leave to go to Newco, but let's say there's a 2-week or 1 month overlap period where I'm still at Oldco, I can't start calling customers of Oldco saying, hey, I'm getting ready to go to Newco, do you want to come with me? Not only would that violate a non-solicitation agreement, it would be a breach of fiduciary duty as well, but that's something you'd want explicitly set forth in a restrictive covenant. I mean, at the end of the day, you don't want your employees to have to guess as to what they can and can't do. You want to be able to articulate that to them in the agreement. You want to remind them of that at various intervals, train them on that, put it in an employee handbook as well. But just making sure that employees know what is and is not allowed is very important.
I remember when we were preparing for this, I think Larry made the point that when talking about reminding employees that a good time to do that might be during the annual reviews and make all these agreements as part of that process. Is that something you've seen folks use, Larry or Eric?
Well, I sure wish more of them did it, since sometimes it's a surprise to folks, to realize they've forgotten they've been in a company for 10 years, they signed an agreement 10 years earlier, nobody's even sure where it is. It is, to the extent that a person argues, and they'll argue this, that, look, this was never mentioned, it's not how the company does business, 100 people have left this company, and I've never seen any of them dragged into court. This is personal, this is just to keep me from working as opposed to preventing some particular harm. If part of the annual process of reviewing people is to remind them, I mean, the boxes that they check, including, I have read, once again, my non-compete and non-solicitation agreement, it's hard for that person later to say, I never believed I was subject to it, or better yet, I don't believe the company takes this seriously. The company also has to look at its own previous record in enforcing these things when it goes to court to get an injunction, and be prepared to explain why this is finally the one that has spurred them to action, whereas the previous 20 vice presidents who left didn't get so much as a scowl when they left and started taking clients. So it's if you're Oldco, you're writing this thing with enough teeth that it's going to make Newco understand that the cost of buying your employee and buying the customers that go along with that employee is higher than the check they're writing to that person to bring them on board. And as NewCo, you have to be thinking of that when you're budgeting. You have to think about what am I getting for bringing Eric Meyer on board, and I'm going to get Eric for $150,000, and he's going to get a bonus structure like this and like that. And you have to be thinking about the $150,000 you're going to spend on the litigation, that at the end of the day you're probably going to work out an agreement with OldCo as to who they can talk to, who they can't talk to, or a certain amount, a moratorium on any conversations, and maybe even a cash settlement. But it's about making a good enough agreement that it makes it more difficult that it just makes it more expensive for NewCo than simply the price of luring the person away. But the same things with regard to non-solicitation. You have the same issues with regard to non-solicitation when you're NewCo that you had with non-compete, and that is, don't find out the first day this person's subject to a non-solicitation agreement, especially if this is a person you hired not for their smarts or for their ability to solve Rubik's Cube, but for their relationships with customers that they developed over 20 years. You're going to also look out for, as OldCo, look out for the exception. The person says, well, I'm not taking any of your customers. These are customers I brought to you 10 years ago when I first came on board. Make sure that's addressed when you're OldCo in the document. And when you're NewCo, look for that hole and make the argument that you're not taking any of OldCo's customers. Your new employee is simply bringing along his friends and customers that were always his all along, or always hers from the previous job. I can't think of anything particular to the non.
Yeah, I think Larry, I'm going to jump ahead a few slides because I want to save some time for questions. I've seen quite a few queuing up. So
yeah.
One of the more interesting areas, I think, in terms of newness is just social media. So don't mind me as I click through here to get to that slide. We talked about trade secrets already. So social media as a solicitation tool, customer lists, inadvertent or intentional disclosure of information. What should the folks out there be looking for with respect to Twitter and LinkedIn and Facebook?
Well, let's first talk about LinkedIn, and let's use a hypothetical. I leave OldCo. I have a LinkedIn profile. I update my LinkedIn profile to show that I no longer work for OldCo, but now I work for NewCo. That updated LinkedIn profile then gets blasted out to all my connections, several of whom are current customers of OldCo, my contacts that I've had for a while who happen to do business through me with OldCo. Have I just solicited them? No. I mean, it's 2015, and folks and even courts generally understand that if someone updates their LinkedIn profile to reflect that they now work for a new employer, that's not a solicitation. But if you send out a blast to all of your LinkedIn connections, separate and apart from updating your profile, akin to a group email or a group text or meeting a bunch of people in the park, all of your customers in the park, to announce that you've moved from OldCo to NewCo, will you come do business with me? That's an unlawful solicitation if you have a non-solicitation agreement. And then, of course, the gray area is a hybrid. What if you update your LinkedIn profile to show you're at NewCo, and then one of your customers from OldCo reaches out to you and says, hey, I didn't know you were working at NewCo now. I'd like to do business with you. That all depends on how restrictive the non-solicitation agreement is drafted. Technically, you are not doing any soliciting as the former employee. You are being solicited. But if the non-solicitation agreement is broad enough to include any form of communication, then the safe thing to do as the employee and NewCo, who is ostensibly aware of these restrictive covenants, is to probably keep hands off and target someone else. In terms of the impact on customer lists, now that everyone's so connected on LinkedIn, and it's fairly easy to reverse engineer who may be customers of Oldco, the proprietary value of a quote-unquote customer list, even under the Uniform Trade Secrets Act, is diluted severely. And that's generally an exception to the rule of a quote-unquote confidential or trade secret customer list. If that information is generally available in the public domain or can fairly easily be reverse engineered, then it's not going to have that trade secret label attached to it, so it's not going to be protected. Disclosure of trade secrets, same rules apply. The issue with social media, I mean, it's just another form of communication, but what makes it so special and so potentially damaging is the viral nature of social media. I mean, if you Google it now, Google Raising Cane's, C-A-N-E''S. I'm not familiar with this restaurant franchise. They don't have them up here in the Northeast, but I understand they're pretty big down in Texas and Louisiana. You had a former employee. Yeah, you had a former employee of Raising Cane's, someone who worked in the kitchen, who apparently knew the recipe for the secret sauce. And after he was fired, I think it was a he, this person went on Twitter and claimed to, posted a recipe that he claimed was for the secret sauce, to literally the secret sauce for Raising Cane's, for their chicken fingers. Raising Cane's subsequently denied that it was the secret sauce, that only managers know the secret sauce, but once this person put it out there on Twitter, it was retweeted and retweeted and retweeted, and now it's no longer a secret. Now, certainly, Raising Cane's could try and do something about it if it were, in fact, the secret sauce and go after the employee, but a lot of good that's going to do. That employee's not going to be able to pay for the value of the lost trade secret, but it's out there. It's out there, and imagine, no disrespect to Raising Cane's, but if this happened to be the 27 herbs and spices to KFC's chicken or the Coke formula, I mean, it could be really, really harmful. And once the rabbit is out of the hat on social media, it's gone. Other issues relating to social media, just so we can leave time for questions, I'll do it real quickly, is the issue of who owns the account. The case that people want to look up is Eagle versus Morgan. It's a case out of the Eastern District of Pennsylvania. It involves an employee, a C-level employee, who set up her own LinkedIn account, but then the company used it for business. She had assistants and folks at the company basically running her account for her. And then when she left, she wanted to take her account with her because she had, as part of that account, all sorts of LinkedIn connections. But the company hijacked the account and changed the password, so she had to go to LinkedIn directly to get her account back. So I mention this only because as a company, if you want to have a corporate social media account, make sure that it's set up as a corporate social media account. Make sure that you read the terms of service of LinkedIn or Twitter or Facebook, whatever you're setting up, and make sure you enter into a written agreement with whomever is your social media manager or whomever is using that account. The other big case is, it's a couple years old now, is Phone Dog versus Kravitz. That's the case out of California where Noah Kravitz, who worked for Phone Dog, had accumulated, I want to say about 30,000 followers on Twitter, and then when he left Phone Dog, he tried to take his Phone Dog Twitter account with him. The company fired back saying, no, you can't do that, sued him for damages, trying to place a value on each individual Twitter follower, but also made a claim that the misuse of the account password was a violation, was trade secret misappropriation, that the password, the login information to the account was proprietary. So, a way to hopefully head these types of issues off is to be very open and upfront with your employees who use social media for business purposes and clearly define which accounts are going to belong to the company, which accounts are going to belong to the employee, and what's going to happen in the event that the employee separates from the company.
Okay, great. Let's jump ahead because we're going to give ourselves some time for questions here. But this last slide on the section is just some things you should be doing now. if it hasn't scared you already, hopefully you will after you think about it a little bit, but it's probably time to go back, review, update your non-compete, your non-solicitation agreements, make sure people know where they are, they can find them. If you want to change your review process to make sure that the employee acknowledges them, now's the time to start planning to do that. The legal team, both outside and inside counsel, partnering with HR on just reviewing the procedures and the process generally, your exit interview process, making sure you have one in place, it's being followed, that you're onboarding and offboarding people properly and all the agreements are getting signed and stored. If you're, whatever version of agreements you're using, one form, multiple forms, you need to maintain version control. You don't want people kind of freelancing it, cutting out a paragraph from here or there and sticking it into an agreement, or using an agreement from 2 years ago that hasn't been updated. And then lastly, just looking at what is your inventory of trade secrets generally, and what should you be doing from a strategy standpoint to protect those. And I think it was either Larry or Eric who said earlier, it's much cheaper to involve outside counsel at the beginning than it is at the end, because that's when the cost is going to go up astronomically. So this is a good place to really partner with your HR team, with your outside counsel, and get this thing and get these in place. And
yes, I can read you a few of the questions that have came in. One of the questions is it appropriate to combine the non-compete and non-disclosure in a single agreement?
Yes.
Yes. Next.
Okay.
I mean, it's a great, provided, as long as, don't try to do too much with it. Make sure your non-compete's defined very clearly. Make sure your non-solicit's defined very clearly. No reason it can't be in the same.
Okay, great. Thank you. Another question that has came in, does an employer's failure to secure non-competition and trade secret agreements from an employee potentially preclude the former employer from arguing it took reasonable steps to protect its confidential information?
Does it preclude that? No. Does it make it a little bit more difficult? Yes. And I think there's some other extrinsic factors which you'll have to consider. Even if you don't have your employees sign a particular agreement, how are you treating your quote-unquote trade secret information? Are you following many of the protocols that Larry laid out earlier? Do you have an employee handbook provision which recognizes or reminds employees about the proprietary nature of certain information? It's going to be, you're going to have a really hard time, I think, unless you happen to fall under the particular set of facts and circumstances that maybe mirror the the Bimbo versus Botticelli case of stopping someone from going to work elsewhere. But in terms of protecting your trade secrets, yes. Plus, you always have the Uniform Trade Secrets Act, which is statutory. So even if you don't have any sort of writing that reminds employees of their obligation, you have the Uniform Trade Secrets Act that you can always fall back on.
But if you have the combination of the companies never try to enforce anything against anybody, and they didn't put any kind of agreement in your place, that's going to be a factor the court takes into account as to how serious you were about protecting anything.
Okay, thank you.
Yep. Next question.
Another question is, do you have any general framework for the level of consideration needed to enforce a non-compete entered into post-hiring, understanding that courts will differ on such things?
It depends. We get that question a lot, and I really don't know the precise answer. Obviously, the more consideration you throw at a person, the better. If you're giving someone a big bonus, and I can't tell you what big is, a promotion, a combination of consideration elements, that's going to be better than just giving someone the proverbial peppercorn, which I don't think would hold up. But I really don't have a hard and fast number. Certainly nothing that could be applied universally in all 50 states.
But a change in job duties that increases the amount, that increases the scope of the agreement is probably going to have with it an increase in salary and an increase in bonus potential that certainly would be helpful.
Okay, thank you. We did get quite a few questions, so here is another one that's a little bit different. It says, what do you think about asking your in-house counsel to sign a non-compete agreement?
For the most part, unenforceable, maybe in all 50 states. All the different Supreme Courts, I mean, they're going to treat that the same way they're going to treat a lawyer trying to do a non-compete with a lawyer in their own firm. Somebody's going to, every Supreme Court at some point has made the point that at the end of the day, we have to preserve the client's ability to pick the lawyer of their choice. So other than being able to raise conflicts as an issue, I don't know whether you can really, I've never seen it, a successful non-compete for an in-house lawyer.
Yeah, it's pretty tough.
Pretty tough. You were there.
Well, I signed it, but I can tell you that I did scratch my head a little bit. I knew I still have obligations to the client on confidentiality and things I could work on, but it would be odd. I think you would be in a tough position as an in-house counsel and refusing to sign the non-compete. I don't know how that would play out, but it was an interesting question. I did think about it. So,
yeah. I mean, to me,
I never ran afoul of it. So.
Yeah, you're going to have lifelong confidentiality obligations that are going to protect Old Co. And right, it's certainly not going to get you your next job if you don't sign it.
Okay, good insight. Here is another question. What is the difference in legal liability for breach of confidential information provision versus breach of trade secret provision?
Well, the Uniform Trade Secrets Act has an attorney's fees component to it. So if you're found to have misappropriated trade secrets under one of these statutes, there's going to be a mandatory recovery of reasonable attorney's fees and costs, whereas the quote-unquote confidential information, which is going to be the subject of an agreement between the employer and employee, there's no requirement that attorney's fees be recovered unless, of course, and most employers will do this anyway, have an attorney's fees provision in that agreement that says something along the lines of, if we have to enforce and we prevail, among the damages that we can recover are our reasonable attorney's fees and costs.
Okay. Another question that came in, can a business have a non-compete agreement with an independent contractor who is not an employee but working inside the firm?
Well, by its very nature, an independent contractor is supposed to be able to work with a number of companies. If the independent contractor were simply seconded to one company, it's starting to look more like an employee, and there may be some Fair Labor Standards Act issues. So is it feasible to do it if it's narrowly tailored, that you're, after working for company A, you're not going to do any work for B, C, and D, but you can work for E, F, and G, who are also our competitors? I think you'd have a better shot there, but a global, more all-encompassing non-compete that says you can't work for any competitor within any particular or a certain geographic surrounding, I think that's going to be tougher. A non-solicit is more likely to be enforced because obviously you don't want your employee or independent contractor leaving and then going after your customers, but a non-compete is going to be a more difficult argument.
Yeah, I agree with Eric. I would do non-solicit and trade secret, but you get a non-compete and you're flirting with making that person an employee, and you have then opened up a whole hornet's nest of obligations you have to that employee, to that independent contractor.
Yeah, the only other thing you might consider, I wouldn't recommend it, is you'd have some type of exclusivity agreement and you paid some additional compensation, but I don't know if that would last, beyond the term of the engagement, so I don't know if that actually gets you anywhere in the end of the day, but
yeah,
during the actual project.
We're just talking now about contracts between arm's length parties at that point, and not employee ones. I mean, what makes these unique is that it's an employee and the bargaining position isn't strong, and that's why the courts are going to make you jump through all these hoops. Some big consulting company and some big company getting in a fight over what they can do next. So the courts aren't going to look at it with viewing anybody as the person they have to look out for. And I don't mean that as a shot at the courts. I just mean that you're talking about 800-pound gorillas at that point having a fight.
Mm-hmm.
Yeah, I agree.
Okay, I think that you had already given an example of a restrictive covenant. However, someone asked if there's some other examples of consideration to give for restrictive covenants other than New Jersey.
Well, the three that I'm aware of are continued employment in a state like New Jersey, initial employment in just about every state, or some kind of added benefit if you're doing it midstream, a bonus, a promotion, a salary increase, or some other form of sufficient consideration to support entering into a restrictive covenant midstream. The last thing that may fly, at least in Pennsylvania, and the Supreme Court is about to determine this, is whether you can put the words intending to be legally bound into the agreement and have the employee be bound without any other form of consideration. It's called the Uniform Written Obligations Act here in Pennsylvania, and the Supreme Court here is going to determine whether that can suffice for consideration. The Superior Court said no.
Yeah, and I think it underscores things that you should be doing now with respect to, since all the states are potentially different, you really should focus in on where do you operate, or where do most of your employees operate, or where do the most valuable employees operate, and really dig down deep into the laws of that state so you have a real good understanding of what the issues are now versus after someone's walked out the door and you're scrambling to get a TRO in place or something, when that's not the time to be doing the research on what the best laws are or issues are for your venues.
Okay, great. I think we have time for one more question. One more question would be, do you recommend including a liquidated damages provision in a non-compete agreement?
I really don't. I think liquidated damage provisions, I mean, you are looking for first and foremost injunctive relief here. And if you can prove harm that came from losing a client or losing a trade secret, there is relief for that. Liquidated damage provisions are really hard to enforce. They look like penalties, and the courts look at these things carefully to begin with, and I worry about the one-sided nature of liquidated damages.
It also may water down your argument that the harm is irreparable, because you put a value on the breach. That's the liquidated damages provision. So you may not be able to get injunctive relief. One element of injunctive relief is showing irreparable harm, and that may be difficult with a liquidated damages provision.
Yeah, that's what jumped out at me, was that issue. Yeah.
Yeah, it was frustrating for in one of the cases we worked on where the court was like, what do you mean you can't tell me after 3 years how profitable this transaction is? I'm like, because there are so many factors that go into it, and it's valued over so many years. It is impossible for us to tell you a number, because the judge was not interested in issuing an injunction, but was interested in writing a check. And we wanted an injunction, so we couldn't just come up with a number, but in part because we couldn't support one.
Okay, thank you. We have had several questions, but in the interest of time, I believe that we will need to close out today's webinar. Kathleen, would you like to do the closing, please?
I'd be happy to. On behalf of LexisNexis, we would like to thank Sterling, Eric, and Larry for an outstanding program today. For our attendees, please take a moment to complete the survey, as it does provide us with excellent feedback so we can continue to tailor programs that you would like to see the most. Thank you all, and have a great day.
Thank you all.
Thanks, everyone.
Thank you.